is Gavin Barrett. I'm a professor in the School of Law, the Sutherland School of Law in University College Dublin. And the first thing I should say is mi scuse per non parlare italiano. I'm going to say this in English. And I just want to talk a little bit about the research that I am doing over here at present. I'm actually looking at a judgment, a very recent judgment of the Irish Supreme Court that was handed down on the 11th of November 2022 called Costello against the government of Ireland. And in that case, the Irish Supreme Court, by a very narrow majority of 4-3, upheld the appeal by Patrick Costello, who is a Green Party Member of Parliament, an appeal against the refusal of the Irish High Court to declare Irish ratification of CETA, the EU-Canadian trade agreement, unconstitutional. So they upheld that appeal by a 4-3 majority, which effectively makes Irish ratification of CETA unconstitutional. Now, all 7 of the judges issued separate judgments, and some of them are very lengthy indeed. All told, they come to 476 pages in total, and very much represent a move away from the approach under former Chief Justices of the Court of trying to produce 1 or 2 collective judgments. So it's quite a job working one's way through all of these rulings. There's one clear point of agreement in all of the judgments, and that is that ratifying the EU-Canada trade agreement is not an obligation on Ireland necessitated by membership of the European Union. And that means it enjoys no special constitutional protection. So in other words, its constitutionality is judged under the ordinary rules that apply, the ordinary constitutional rules that apply to executive action by the Irish state. Now, as I said, it was a 4-3 ruling in favour of unconstitutionality of ratification. But the two, if I can describe them as this, the two dominant judgments in the case are that of Mr. Justice Hogan in the majority and that of Chief Justice O'Donnell in the minority. Now, if I can deal very quickly with the judgment of Chief Justice, or I beg your pardon, with Mr. Justice Hogan, he held that ratification of CETA would be unconstitutional, and he felt that the enforcement mechanism for CETA tribunal rulings in Irish law made them quasi-automatic. They're enforced under the legislation that's normally used for arbitration awards. So he felt that made them quasi-automatic. He took the view that CETA tribunal awards violate Irish legislative sovereignty because they introduce possible liability for legislation by the Irish state. He also felt that the powers of the CETA tribunal violated judicial sovereignty as well, so effectively the sovereignty of the state represented by the power of the courts as well. And thirdly, he felt that the power of CETA joint committees to make binding interpretive decisions also violated the democracy guarantee in Article 5 of the Irish Constitution. So a range of constitutional provisions there he held violated by them, and he was joined in that, his condemnation, constitutional condemnation, by Mr. Justice Charlton and Ms. Justice Dunn and Ms. Justice Baker in relation to that. Then in the minority, the Chief Justice issued what to my mind was a devastating riposte to the ruling of Mr. Justice Hogan. It wasn't enough to convince the majority of the court, but I find it the more convincing ruling in which he denied that CETA tribunal rulings would be quasi-automatic. He felt that there was no violation of legislative sovereignty and no breach of juridical sovereignty either. And now, the interesting thing was that both Mr. Justice Hogan and Chief Justice O'Donnell took the view that any constitutional infirmity could be cured essentially by, if you like, loosening the enforcement mechanism in Irish law, which is important because it means that a referendum can be escaped. If they're correct in that, it means that a referendum can be escaped. It won't be necessary to amend the constitution in order to save the constitutionality of ratification of the CETA agreement. Now, Mr. Justice Charlton in the majority felt that a constitutional referendum would be necessary, but he was alone in this. All of the other judges took the view that merely softening the legislation, if you like, and the enforcement mechanism and making it less binding would or less automatic, I should say, would cure any potential constitutionality. So that seems to be the position there. In terms of the consequences of the judgment, ratification of CETA is now unconstitutional, and that's serious at an Irish level because Ireland needs to retain its attractiveness as an investor destination, but it's also very serious at European level because the EU-Canada trade agreement is a mixed agreement, and that means in order to be ratified, it must be unanimously ratified by all of the member states, and now one of those member states is missing at this stage. Now, the consequences are less serious than they might otherwise be because the non-investor parts of the treaty have been applied provisionally by the member states. So in other words, the free trade parts of the agreement are being applied already. So if you like, that softens the blow that this case actually represents. And as I said, secondly, it appears to be less serious in the sense that most of the court felt that mere legislative change in Ireland might cure any constitutional infirmity. Now there's perhaps some doubt that if you like, softening the enforcement mechanism is compatible with with the treaty, if you like, with the EU Canada trade agreement itself. The Chief Justice, however, was having none of that. So I think we can hope that the blockage produced in the ratification of CETA by this ruling will prove temporary and not too great a difficulty. That much said, investor arbitration is proving increasingly controversial all around the world. The CETA tribunal system, though, is actually a compromise between arbitration and a full international tribunal. So, you know, it's interesting to see, if you like, how it's been sized up by national courts in this regard. But it is important to realise that it was an aim to move away from the secrecy of international arbitration at the moment and deliberately to create a more permanent kind of adjudication at European level. You know, I think it probably would be desirable to see this system survive, if you like, as a viable alternative to international arbitration. Just one or two other reasons why the case is really significant. The notion of constitutional identity was raised by many of the judges in this case. That's a concept that originated in the Bundesverfassungsgericht, the German Constitutional Court, has been mentioned at this stage as well in the rulings of the European Court of Justice. It has now definitively spread into Irish law as well. So I've heard it described as a new form of sovereignty, but in actual fact sovereignty is very much mentioned in this case as well. It's explicitly mentioned in the Irish Constitution. So now we have constitutional identity featuring there as well. The speculative nature of what the court was deciding, because of course the CETA tribunal hasn't actually issued any rulings yet, and I think that had to represent something of a concern. There was an air of unreality of what the court were talking about in this case. We don't know what CETA is going to decide, and that's a little bit unsatisfactory. But on the other hand, if you're going to allow, as the Irish system does, challenges to ratification, perhaps that is inevitable. There were issues raised also of a possible, what I might call, per incurium issue here as well. And what I mean by that is that the Chief Justice noted that the judgment of Mr. Justice Hogan went a long way beyond the arguments that had actually been raised by the parties in the case. He did express some concerns about that as well. But be that as it may, the judgment stands at the moment, and for the time being, Irish ratification of the EU-Canada trade agreement is unconstitutional.